Chapter 4, Section 8, the 14th Amendment and Due Process. The Due Process Clause of the 14th Amendment holds that state governments cannot deprive any person of life, liberty, or property without due process of law. After many years of legal interpretation and court rulings, due process protections have developed to include prohibition of warrantless searches of premises, such as homes or offices, and private papers, including cell phone data as well as traditional written communications. The exclusionary rule, banning prosecutors from using illegally obtained evidence, the Miranda rule, requiring law enforcement officials to inform accused persons of their rights prior to interrogation, and pretrial rights for accused persons, including legal counsel, a timely and public trial, and decision by a jury of peers, among other protections. Due process protections are meant to shield people from arbitrary government action. The practical effect of due process is that governments are limited in whether and how they can control the actions of people within their jurisdictions. Due process also affects what the government can do to deprive people of life, liberty, or property, if need be, such as in a criminal case. If a government violates due process, whether through a law or in action, it can be sued by the person violated. Due process violations can happen during court cases and criminal investigations, and since the stakes are high in those situations, courts take such violations very seriously. Examples of due process violations could include a judge refusing to appoint or allow a defendant to have an attorney, police coercing a confession from a suspect and the prosecutor using that confession at trial, police improperly seizing evidence and the prosecutor using the evidence at trial, or charging someone twice for the same offense, double jeopardy. If a defendant alleged any of these things and could prove that the authorities acted improperly, the defendant could demand a new trial or have the conviction vacated. Since the protections for fundamental liberties in the Bill of Rights have all been effectively held to apply to the states through the 14th Amendment, states and their agents, police, district attorneys, judges, and other officials, must meet the same standard that federal officials must meet in any area covered by the incorporated rights. This has had the effect of changing trial procedures and police conduct as individual state regulations have been changed by incorporation over time. The right of privacy. There are several amendments that seem to suggest a right to privacy, especially the 4th and 5th. For most of the court's history, the justices did not subscribe to this view and ruled accordingly. In the 1960s and 1970s, however, several cases were decided in accord with the general expansion of civil liberty protections in that era, establishing a right to privacy in certain circumstances. One of the important privacy cases is Roe v. Wade, 1973. In Roe, the court held that the right to an abortion was implicit in the privacy right in the 4th Amendment and limited the ways in which the government could regulate the abortion process. The court issued several decisions based on the idea of a right to privacy, but struggled to articulate the precise boundaries of that right. These decisions generally concern matters of sexual choice and bodily autonomy.